taking that swab and swabbing the dark spot?
Taking a swab for presumptive tests and collecting are two different things.
After you took the swab and rubbed the dark spot on July 6th, was any red stain left?
I don't recall if any was left or not. I don't think I used up the whole stain.
Well, if you didn't use up the whole stain, did it ever occur to you to suggest somebody should go back and take a picture of what was left?
No,
Never made that suggestion to anyone.
no,
Ms. Clark never told you to go back and take a picture of it.
no.
Didn't you tell someone on August 8th, with respect to this investigation of the Bronco, that you did not remove any evidence on July 6th, and you did not notice any papers in the vehicle at that time either?
I didn't look for papers in the vehicle.
Are you sure, sir, that you did not tell someone from the LA Police Commission that you visited the vehicle on July 6th to refresh your memory for court, and you didn't remove any evidence from it?
I don't recall the exact conversation. I don't even recall talking to somebody from the LA Commission, Police Commission.
One moment. Mr. Fung, before we leave this topic, let me just show you some documents to see if they refresh your recollection.
Sustain.
Well, you've indicated that you don't recall speaking to anybody from the Los Angeles Police Commission with respect to your visits to the Bronco.
I don't remember any specific conversations, no.
All right,
Couple more questions.
I'm sorry?
Couple more questions.
All right. Would it refresh your recollection, sir, to examine some documents as to whether or not you had any conversations with someone from the Los Angeles Police Commission with respect to your visits to the Bronco?
Call the roll.
It may but I don't know what the source of the documents are.
All right. May I approach, Your Honor?
You may.
Yes. Your Honor, I asked that...
Why don't you just show it to counsel?
Yes.
So the court can see, take a look at this.
I'm aware of what these documents are, counsel. We had a whole proceeding on these documents.
May I approach the witness, Your Honor?
Please.
Mr. Fung, please take your time, showing you a series of documents, and in particular, I'm going to address your attention to paragraphs, the page that's marked here, 1187, and there's another short one here. I've tabbed them with yellow Post-its. Please take your time, look at all the documents for as long as you want. Sir, having examined these documents, is your recollection refreshed about having a conversation with anyone on August 8th about your visit to the Bronco on July 6th?
Even from reviewing those notes, or that report, my memory is not refreshed.
So as far as the way you would like to leave it, sir, is that you never,
Phrase the question.
is it your testimony, sir, that to the best of your recollection, you were never interviewed by anyone from the Los Angeles Police Commission with respect to your visit to the Bronco on July 6th?
Sustain.
Were you interviewed by anyone from the Los Angeles Police Commission on August 8th, sometime in August, about your visit to the Bronco on July 6th?
I don't recall any personal interview. It may have been telephonic.
Well, do you recall a telephonic interview?
No, I don't.
And is your testimony, sir, with respect to red stains in the Bronco that you're given to this jury in any way motivated by a desire to cover for Detective Furman?
No.
Now, I'd like to turn to a new topic, Your Honor. I won't be able to finish it before the break, but might as well
Try.
start. I can't.
Try.
I'll do my best, but we're going till 12? Mr. Fung, you've told us that on the afternoon of June 13th at Rockingham, you received Mr. Simpson's blood vial from Detective Van Adder.
Yes,
You did not receive this blood vial for the first time on the morning of June 14th.
that's correct.
Now, did you discuss in your preparations for this case, the district attorneys, this issue as to when you received the blood vial?
Or Susan's issue.
Phrase the question.
Did you discuss with the district attorneys the circumstances of how you received the blood vial in this case?
Yes,
And was that an issue that you discussed at some length?
about 15 minutes.
Did you discuss the issue about how you received the blood vial with Michelle Kessler,
I don't believe so, no.
with Greg Matheson,
No,
with Detective Van Adder,
by issue, do you mean why it was done that way, or?
did you discuss with Detective Van Adder before you came here to testify, preparation for your testimony, the circumstances surrounding your receipt of the blood vial from him?
No,
Compound.
Oral.
Did you have any discussions with Detective Van Adder concerning how Mr. Simpson's blood vial was turned over for purposes of booking?
could you repeat that question?
Could you tell us, you said did you have some discussions with Detective Van Adder about Mr. Simpson's blood vial?
Yes,
When?
the day I received them from him.
Since then, any discussions?
Not to my recollection, no.
Any discussions with respect to the decision to bring the blood vial from downtown to you at Rockingham?
No,
Did you discuss the circumstances of receiving Mr. Simpson's blood vial with Detective Lang prior to coming in here and testifying?
I don't recall any discussion about that, no.
So other than the prosecutors, in preparation for your testimony, you have not had, withdrawn. Did you discuss the circumstances of the receipt of Mr. Simpson's blood vial with Andrea Mazzola?
I only stated to her that we did receive, or I did receive the blood vial from Detective Van Adder.
When did you have that discussion?
That was the morning of June 14th.
Now, who was present, according to you, at Rockingham when you received the blood vial from Detective Van Adder?
We were in the foyer, and I was there, of course. Detective Van Adder was there. And I know there were other detectives around, but I don't recall who they were exactly at
There's-
that point in time.
So you're saying that was in the foyer of Mr. Simpson's home?
That's when I received the envelope containing the vial of blood.
That was inside.
Yes.
Was the door closed?
I don't recall.
Can you describe for us in as much detail as you can recollect exactly how this transfer occurred?
Detective Van Adder said to me, or something to the effect of, I have Mr. Simpson's blood, and I want you to book it.
Now, you made a gesture with your hand.
Yes.
And are you indicating, sir, that he then gave you something?
Yes, that he gave me the envelope containing the vial.
All right. And where was he? Was he holding it in his hand?
Yes.
Did you see, when did you first see Detective Van Adder before he gave you this envelope?
I don't recall exactly when he came, but I do recall that particular
And
event.
did he take it out of something, or did he just have it in his hand?
I don't recall.
Did he pull it out of a black duffel bag and give it to you?
I don't recall him having a black duffel bag.
You didn't see him carrying a black duffel bag.
No.
Did he take it from a clipboard and give it to you?
I don't recall him having a clipboard either.
So, to the best of your recollection, Detective Van Adder handed you a gray envelope, and he just had it in his hand.
To the best of my recollection, yes.
And then, after you received that gray envelope, what did you do with it?
I wrote on the envelope that I received it from him, and I put the time, date, and my initials.
And what did you do with the envelope at that point?
I looked inside to make sure that there was a vial in it and that it was in a condition that was unopened, and I put it in the crime scene truck.
Well, we're still in the foyer when you got it, correct?
Yes.
Did you open it, the envelope in the foyer?
Yes.
And that's when you looked at it?
At the vial.
Yes.
Yes.
And when what did you have with you at that time, if anything?
I had a pen.
And after you received the envelope from Detective Van Adder in the foyer, did you then walk out the door to the crime scene truck?
I don't know if I did that immediately or if I had other things that I had to do prior to that.
Did you put this envelope in a brown paper bag?
I don't recall if I did or not.
Did you put it inside your black kit?
No, I don't think I did that.
Did you, at some point, walk out of the foyer to the crime scene truck holding the gray envelope?
I don't believe so.
Well, what did you do with it? How did you get it to the crime scene truck?
It may have been in a paper bag, but I don't recall if I actually did put it in there, or it may have been put in a posse box.
It's possible you just walked out the door with the envelope in your hand?
It's possible, but I don't think that's likely.
All right, Mr. Scheck, we're going to take our break at this time. All right, ladies and gentlemen, please remember all of my admonitions to you. Do not discuss this case amongst yourselves. Do not form any opinions about the case. Do not allow anybody to communicate with you. Do not conduct any deliberations till the matter has been submitted to you. We'll stand in recess until 1:30. Mr. Fung, you're ordered to return 1:30. All right, we'll stand in recess, and greetings to Judge Scott. Thank you. Mr. Scheck, you had a discovery issue you wanted to raise?
Yes, Your Honor. And I would request that the witness be asked to leave the room for a moment.
All right, Mr. Fung, would you wait outside for a few moments, please? Thank you, sir. Mr. Scheck.
Thank you, Your Honor. Your Honor, as I'm sure the Court is well aware, one issue of great interest in this case are the activities in the at SID on the morning of June 14th. And discovery request was made for computer records that reflected who went in and out of the doors in various rooms at SID. And the prosecution, in particular the evidence processing room on the morning of June 14th. The prosecution turned over to us a series of pages starting in the murder book at DA 04329 to DA 04334. Actually, these pages are backwards in terms of chronological order. That is to say that 04329 purports to be records of June 16th, and then they go from the 16th to the 15th,
Probably that's how it came out of the photocopy machine.
whatever it did, the 14th to the 13th. The problem is, however, with respect to, on page 04333, we received records about June 14th, and those were the only records we received. The records of June 13th were then contained on 04334. So these are consecutively numbered pages. We noticed this morning, in preparation for court, that the first entry that we had on June 14th for someone entering the evidence processing room was 9:27 a.m. Actually, what I'd request is that perhaps these pages be marked as exhibits at this point in time.
All right. Defense next in order, which would be 1099.
My colleague, Mr. Neufeld, who is a bit under the weather, has been monitoring these proceedings from his hotel room and made a telephone call to Greg Matheson at SID during the course of the testimony of Mr. Fung and made an inquiry as to whether or not there was an additional page reflecting who went in and out of the evidence processing room on June 14th. And again, Mr. Neufeld was reviewing those records that I've just mentioned to the court. Mr. Neufeld informs me that Mr. Matheson confirmed that we were indeed missing a page with respect to earlier times, but indicated that he did give that page to the district attorney's office. Mr. Neufeld has read to me over the phone information that he received from Mr. Matheson with respect to the times.
On the 13th or the 14th?
I'm sorry, on the 14th.
Right.
The times of the 14th, and the missing page. And those times contradict, I believe, the testimony of Mr. Fung. We have Mr. Fung in the evidence processing room at 7:45, Then we have him back entering the evidence processing room at 7:50, and we have other individuals in and out of that room starting at 6:03 a.m. And my concern, Your Honor, is that we didn't get this page and the consecutive numbering of the documents. And obviously, would we request an explanation for the prosecutors? If this court were to make a finding that this document was deliberately withheld, what we would ask is that we get an actual copy of this document to the court, that we confront Mr. Fung, but most importantly, that the jury be instructed that the document was intentionally withheld, if that in fact turns out to be the case. All that I can do is relay the information that I have. It's a matter of concern to me, but of course I await the explanations from...
All right, Mr. Goldberg?
Your Honor, I think counsel has unintentionally misstated the record. I don't believe the defense ever made a request for access in or out of the room. The way it came about is I asked for those records for the purposes of trying to determine certain time sequences, and voluntarily produced them to the defense without any request whatsoever. So I'd ask Mr. Scheck, if he can, to find the citation in the transcript where that was requested, because I'm simply unaware of it.
Oh, I don't dispute that the events may have occurred that way.
Well, Mr. Scheck, before we launch into that issue, the issue that I'm concerned about now, since I have a jury waiting, is where is this document? Can we make it available for Mr. Scheck to examine and for both sides to examine? And let's continue with the cross-examination and redirect of Mr. Fung. And we can take up to the issue of where it was and why it didn't show up in your package at a more appropriate time. But I would like to get finished with Mr. Fung today.
You know, I just would like to say for the record that what I have in my notebook is identical to what counsel just described. And I personally Xeroxed it and have delivered it to them, which probably accounts for why it's in reverse chronological order. Xeroxing is not one of my strong points. But I would just like to say for the record that I just think it's unfortunate that every single legal issue that is raised is always couched in terms of some allegation of misconduct. And I just think it's a very sad way to litigate a
Counsel,
case.
I'm not immediately leaping to that conclusion, so don't get your feathers ruffled up at this point. My concern is let's proceed with the cross-examination. Can we get this document? Can we get somebody to fax it to the court?
I want to be clear, I'm just stating the facts, and I would certainly concede that I do recall that we did have that conversation, more or less as Mr. Goldberg says it, in terms of we were interested in these documents, and he was too.
I can
and he
gauge from your
delivered
tone.
these.
Wait. I'm not interested in this issue.
That's fine with me, Your Honor.
Today, I don't care about it. Later this week, I'll care about it. Can we get Mr. Matheson to fax us the sheet?
You don't have it either, Mr. Goldberg.
No, I don't see what I have if you want to, Mr.
All right?
No, I believe it.
Who's got the phone number for Mr. Matheson?
I'm ready to proceed without that at the present time.
Do you want to proceed without it?
Well, I can proceed at this point without it, and I thought the court wanted to, get the documents and resolve the issue, and you wanted me to proceed.
No, if we agree that what comes from Mr. Matheson is a copy of the original document, if you feel you need it to cross-examine Mr. Fung further, we'll get it for you, and hopefully we can get it faxed to us in a matter of minutes.
Oh, okay.
Both sides will get a photocopy and we can proceed.
Ms. Martinez is calling Mr. Matheson.
All right,
See if we can have it back.
great. Okay, let's proceed. All right, Deputy McNair, let's have the jurors, please, and can we have Mr. Fung, please? Mr. Dennis Fung is again on the witness stand undergoing cross-examination by Mr. Scheck. Good afternoon again, Mr. Fung.
Good afternoon.
You were reminded, sir, that you were still under oath, and Mr. Scheck, you may conclude your cross-examination.
Good afternoon, ladies and gentlemen of the jury. Good afternoon, Mr. Fung.
Good afternoon.
Mr. Fung, when we left off, we were discussing what you told us about the transfer of the blood vial to you in the foyer of Mr. Simpson's home on the afternoon of June 13th.
Yes.
Now, do you recall what you were doing just prior to the transfer of this blood vial?
No, I do not.
Do you recall that an item number 15 was retrieved from a trash basket in the foyer?
Yes.
And an item number 16 was retrieved from a bench outside the front door of Mr. Simpson's home?
I have checked any evidence of 15 and 16, make a motion to destroy.
Not mentioning what it is, just that there were items in those locations.
All right, I'll allow it to stay.
Now, do you recall that?
Yes.
All right. Now, did you receive the blood vial before items 15 and 16 were collected?
No, I received it afterwards.
And you just refreshed your recollection by looking at your notes?
Yes, I did.
And the notes reflect that those items were picked up at 5 o'clock.
Yes.
And since you're telling us that you received this blood vial at 5:20, you have concluded that this was after those two items were collected.
Yes.
Now, but do you have, as you sit here today, an independent recollection of the order in which you received the items other than looking at your notes?
No.
Now, you mentioned to us that you thought that you put the envelope containing the blood vial in a paper bag or what you called a posse box.
It's testimony.
Sustained.
Well, what is a posse box?
Posse box is a note pad that's metallic. It has a cover on it that you can store. It's a box that's shaped like a notepad, except it can carry things.
Did you have one of those with you that day?
Don't recall if we did or not.
Were you carrying one, to the best of your recollection, that day when you left Mr. Simpson's front door to go back to your crime scene truck on the afternoon of June 13th?
I don't recall if I was or was not carrying a posse box.
All right. To the best of your recollection, how did you carry this gray envelope containing Mr. Simpson's blood vial when you withdrawn? I take it at some point in time you left the foyer area and returned to your crime scene truck,
Yes.
and you were carrying that gray envelope.
Either by itself in a posse box or in a paper bag.
So it would be one of those three ways of carrying it, either out by itself in your hand, in a paper bag, or in a posse box.
Yes.
And when you, okay. Mr. Fung, was it your idea to have Detective Van Adder take Mr. Simpson's blood vial from the Parker Center to Rockingham to deliver it to you?
No, it was not.
Did Detective Van Adder call you up and ask you if you wanted to have Mr. Simpson's blood vial booked at SID and a DR number bought before he brought it to the scene?
No.
Would it not be normal practice upon receipt of a blood vial for a detective to buy a DR number and book it either at Parker Center or at SID so the blood vial could be refrigerated?
Calls for speculation.
Sustained without further foundation.
Do you have knowledge of the usual practices by which blood vial samples are booked in the course of cases?
It's vague as to by criminal lists, sir.
Sustained. Phrase question.
Do you have knowledge of how blood vial samples are supposed to be booked or are withdrawn? Do you have knowledge of how blood vial samples are supposed to be booked by police officers?
I have a limited knowledge of that.
And that limited knowledge comes from the LAPD manual?
In part, yes.
And the practice is that upon receipt of a blood sample taken from a suspect, that the detective is to book it either at the property room or at the SID center.
There's still an inadequate foundation, Your Honor.
Overruled. You can answer the question.
The manual is used as a guide, and that's the guideline for officers, yes.
Has anybody discussed with you the phrase, the manual is to be regarded as a guide?
Irrelevant.
Overruled.
Yes.
Did Detective Lang have any conversations with you about the LAPD manual being considered a guide, but not a guideline, or just a guide to govern the conduct of officers?
I have heard him say that, and I've heard many other people say that also.
When did you hear Detective Lang talk about the rules in the LAPD manual being guides?
I don't recall when. It was sometime after this investigation started, though.
About how long into it?
I don't recall when. I do recall him as being one of the people who said that, though.
And do you recall how that subject came up, that the rules in the LAPD manuals were to be regarded as guidelines?
I don't recall the exact, what led up to that conversation.
Was it a discussion in which you were pointing out to Detective Lang that he hadn't followed the rules in the LAPD manual?
No.
Well, with respect to your knowledge of the LAPD manual, is it not the practice that a blood vial taken from a suspect is to be booked as soon as possible?
There's no foundation in this practice.
Overruled.
Could you please repeat the question?
From your knowledge of the LAPD manual, is it not the rule that a blood vial taken from a suspect
Blood
is
sample.
blood sample taken from a suspect is to be booked as soon as possible?
I don't know if that's exactly what it states.
Well, in terms of your understanding, does that comport with your understanding? Is that consistent with your understanding of what the rules require?
That's vague and that foundation
Overruled.
also calls for hearsay.
Overruled.
That's somewhat consistent with the exact wording or of what the manual wants.
And in terms of your understanding of the manual, the practice in this case should have been for Detective Van Adder to buy a DR number down at Parker Center and book Mr. Simpson's blood vial either at the Parker Center or at SID.
Calls for speculation.
Sustained.
When we talk about booking a blood vial from a suspect, do you mean that that vial in the analyzed evidence envelope is handed to somebody at the evidence control unit at SID?
According to the manual, I believe the definition of booking is the registering of property into departmental records, or the process of entering into departmental records, evidence or persons.
And your understanding of entering it into departmental records would mean, in the case of a blood vial, such as the one at issue in this case, that it would be turned over to someone at the evidence control unit at SID. That would be one way of doing it.
Well, if we're going exactly to the letter of that definition, as soon as it's marked on some type of departmental record, that would begin the booking process.
When we used the term booking before, all right, withdrawn. Would not the booking of the blood vial be accomplished by taking it to the evidence control unit, handing it to the clerk, buying a DR number, and having the blood vial refrigerated?
In that order?
Yeah.
Couldn't do it in that order.
Buy a DR number and then give it to someone at the evidence control unit so it could be refrigerated.
That would be the final stage of booking.
Could Detective Van Adder, under the rules as you knew them, have done that on June 13th? Gone right over to SID after buying a DR number and give the clerk at the evidence control unit the blood vial?
Calls for speculation.
Sustained.
In terms of your understanding of the rules, would that have been consistent with the rules?
It's irrelevant.
Oh, well.
Calls for speculation.
You can answer that question.
That would have been one way to have done that.
And isn't that the way, in your experience, it's ordinarily done by detectives?
Sustained.
You have been working as a criminalist for 8 years.
10 years.
10 years, my apologies. And you have been doing crime scenes for how long?
Almost 10 years.
And in your experience, is it not the ordinary practice that after detectives get a blood sample from a suspect, that they take it to the evidence control unit and book it there?
In my experience, I have never had a detective obtain a blood sample that quickly.
So it would be your testimony that in your experience, you've never known a detective not to obtain a detective withdrawn. In your experience, what you know is that detectives ordinarily get blood vials from suspects and book it.
Sustained.
In your experience, have you ever before been in a situation where a detective obtained a blood vial from a suspect?
Sample.
Sam-
Sample. You keep saying blood vial.
Okay,
Sample.
thank you, Your Honor. Obtained a blood sample from a suspect, and instead of booking it downtown where it was taken, at SID or at Parker Center, drive it all the way back to a crime scene. Has that ever happened in your experience?
It's irrelevant.
Call roll.
No foundation.
I can't remember one instance where that's happened.
Thank you.
Have we about exhausted this line of inquiry?
To your knowledge, there is a place in Parker Center where this blood vial could have been booked and refrigerated if a DR number had been obtained. You know that.
Blood samples can be booked down at Parker Center.
So, you examined, you've told us, this blood vial.
I looked at it, yes.
And in looking at it, you determined that it had been drawn, at least by the markings on it, at 2:30 in the afternoon.
I looked at the vial to see if it was intact, and I did look at the envelope, but I don't remember all the writing on the envelope.
So you can't tell us whether or not this was actually drawn at 2:30 in the afternoon.
I don't remember. I'd have to refer to the envelope itself.
But as far as you knew, before Detective Van Adder brought it to you, he'd been carrying it around for some hours.
I didn't stop to think how long he'd been carrying it.
Did you inquire of him how long he had been carrying around this blood sample?
No, I did not.
Did you consider that part of your responsibility in terms of maintaining chain of custody?
No, because that would be his part of the chain of custody.
You don't consider it your responsibility as the criminalist that's gathering and booking evidence to determine where objects have been before you get them?
It's my responsibility to record when or where I get things from and when I dispose of them, or not dispose, but remand them into the custody of somebody else.
Well, you were concerned enough on June 13th that you actually opened the envelope up and looked at the blood vial when Detective Van Adder gave it to you.
Yes.
Before withdrawing, Detective Van Adder have any way of contacting you from downtown on the afternoon of June 13th?
Yes.
Beeper? You wear a beeper?
Yes, I do.
Carry a cell phone?
Yes, I do.
You could have been beeped then and called on a cell phone and asked by Detective Van Adder if you wanted to have this blood vial taken from Parker Center all the way across town to Rockingham.
Overruled.
I don't give anybody my cellular phone number. He could have called DHD or the office and had me paged, though.
Could you explain that? He could have called where?
Counsel, you said he's got a pager,
Oh, I'm sorry. You had a pager, so
and he was available by pager.
you were available, could have been called by a pager.
Yes.
During the course of the day, had you been contacted by Detective Lang or Detective Van Adder through that pager?
No.
Were you contacted by Mr. Matheson?
Yes.
You recall being contacted by Mr. Matheson around 12 in the afternoon while you were at Bundy.
I don't remember being called by Mr. Matheson at that time.
Do you recall sometime around midday that Mr. Matheson called you while you were out at Bundy and asked if you needed any help at the crime scene?
I don't recall that.
Didn't happen?
I just don't recall if that happened.
Now, so it's your testimony, sir, that you were never contacted by Detective Van Adder before he brought the Woodville crosstown to you?
Yes.
Now, on the morning of the 14th, you received some tennis shoes from Detective Lang.
Yes.
Now, you told us just before we broke that you recalled this occurring around, what, 7:30, 7:40?
Between 7:30 and 8 o'clock, around that time, maybe a little later,
And this occurred, you say, in the serology lab?
to the best of my recollection.
Could it have been in the evidence processing room?
I don't remember I don't remember Detective Lang being in the evidence processing room.
Well, you told us that when you saw Detective Lang have his sneakers with him, that he was in the serology lab.
Yes.
And the swatches that you'd retrieved from Bundy were in the evidence processing room.
Yes.
They were in a cabinet.
Yes.
It was unlocked.
The cabinet? Yes.
Now, there's a computer printout that shows who enters and leaves the evidence processing room during a particular day.
It records when somebody uses their keyless badge to open the door.
Right. And the way this keyless badge works is that there's a little rubber kind of thing that you put your badge across. Is that right?
There's a sensor in the wall, and it somehow detects the card, and if your card has the proper access code, then it'll let you in.
Now, if you were walking through the door of the evidence processing room, and let's say I was standing next to you, and you used that sensor, your badge, right?
Yes.
The door would open,
Yes.
you would walk in, and I would walk in.
Yes.
But there would be no record that I entered.
That's correct.
The only record would be that you entered.
Yes.
And you indicated before that you reviewed some records with Mr. Goldberg of what they call card transaction reports indicating who went in and out of the evidence processing room on the morning of June 14th.
Yes.
Now, isn't it true, sir, that you entered the evidence processing room at 7:45 on the morning of June 14th?
It's unclear whether he's asking for his personal recollection of the document.
I would have to refer to the document.
Your Honor, I'd ask that this document be marked defendant's next in order.
1100. What happened to 99? We used 1099? Got it. 1100. 1100.
1100. May I approach?
You may.
Mr. Fung, I show you what's been marked as defendant's 1100 and ask you to examine it.
Your Honor, I'm going to object to this, and perhaps we can approach.
All right, with the court reporter, please.
You may continue to...
Hold on, hold on. All right, thank you, counsel. Mr. Scheck.
Your Honor, is it permissible if I approach to this evening?
Certainly.
Now, what do you recognize that document to be, sir?
Except for Mr. Goldberg, you need to not stand between the witness and the jurors.
I've never actually seen one of these documents before, but it looks like one of the, well, I have seen the document before. I take that back. It's a card access document.
And does this appear to be a card access document for the morning of June 14th?
Yes,
And does it indicate, sir, that you were in the evidence processing room at 7:45?
it indicates I used my card for entry, yes.
And does it indicate that you then used your card for entry again at 7:50?
Yes,
Does it indicate that Mr. Matheson was in the evidence processing room at 7:44?
yes, it does.
Now, having looked at this document, is your recollection refreshed that when you entered the evidence processing room at around 7:45, the morning of June 14th, that's where you saw Detective Lang with the sneakers?
I don't recall the sneakers and him being there. That's just my recollection.
But as I understand your previous testimony, you recall seeing Detective Lang between 7:30 and 8 o'clock, sometime around then.
Yes,
That's when the meeting occurred with you, Detective Lang, and Mr. Matheson, to the best of your recollection.
to the best of my recollection.
And looking at these records, can you now tell us, sir, if that meeting could have happened in the evidence processing room?
Your Honor, it calls for speculation because this record doesn't have anything to do with that.
Whole world.
A portion of the meeting may have occurred there. However, I specifically remember the sneakers being in the serology lab, along with Mr. Matheson and Criminalist Yamuchi and myself.
Is there any reason, Mr. Fung, that you don't want to remember Detective Lang being in the evidence processing room with the sneakers when you walked in there?
Sustained.
When you saw Detective Lang on the morning of June 14th with the sneakers, you realized that he had taken them home.
I don't know if he had taken them home or not.
Did he tell you that he had recovered these sneakers from Mr. Simpson's residence on the afternoon of June 13th?
Your Honor, this calls for hearsay.
Sustained.
Mr. Fung, you were responsible for itemizing in your reports when and where those sneakers were recovered.
That's not exactly true, no.
No?
In my report, I am responsible for stating how they came into my custody.
And are you required to determine from the person who's giving it to you where and when the items of evidence were recovered?
It's my practice when I receive evidence from other or from police officers or detectives that I specify that they keep good notes as to where and when they got or recovered the evidence, and I am only going to put down in my property report that I received it, or that I received the evidence from them.
Did Detective Lang show you any notes about where and when he had recovered the sneakers?
No.
Did he indicate to you in any way that he had recovered these sneakers on the afternoon of June 13th?
Sustained.
Let me ask you to assume for a second, Mr. Fung, that Detective Lang had recovered the sneakers on the afternoon of June 13th, brought them home, and then brought them back to SID and turned them over to you. Are you with me on this hypothetical so far?
Yes.
Would that not be a violation of LAPD Rule 510.10?
What is,
Sustained.
Do you know of a rule in the Los Angeles Police Department manual that indicates that evidence and non-evidence shall not be stored in the personal possession of any employee except for certain forgery-related evidence?
Sustained.
May I approach the witness, Your Honor? Show him a document?
Certainly.
Mr. Fung, show you a document. Do you recognize it?
it appears to be a page out of the Los Angeles Police Department manual.
All right, and I'm going to direct your attention.
I object to this. I cannot maintain this document. He's not an expert in it.
Overruled.
Are you familiar with
Let me see counsel at the sidebar without the report. Proceed with increased alacrity.
Yes, Your Honor. Mr. Fung, you recognize this document as being the Los Angeles Police Department Manual Rules concerning booking, custody, and disposition of property. What page from those rules?
It has the same format as the LAPD manual, yes.
And the LAPD Manual rules on the booking, custody, and disposition of property are rules you are familiar with because that's part of your job as a criminalist.
I haven't read this per se, but I do follow the custom that I have been taught in the laboratory.
And as one of the, direct your attention to a paragraph here and ask you to read it to yourself.
Okay?
All right. Does that refresh your recollection that there, we'll call it a rule or a guideline, whichever you like, that evidence shall not be stored in the personal possession of any employee except for forgery-related material?
No authentication, hearsay.
Sustained.
Have you ever been told that evidence or non-evidence is not to be stored in the personal possession of a police officer.
Sustained.
Were you ever given instruction by anyone at SID that detectives are not supposed to store items of evidence in their personal possession?
Sustained. Mr. Scheck, why don't you phrase the question in the same manner that the witness has answered the question. His understanding is from custom that he's been taught in the laboratory. Ask him if it comports with that.
Thank you, Your Honor.
That would be an appropriate question.
In terms of the custom that you've been taught in the laboratory, has it been brought to your attention that evidence or non-evidence shall not be stored in the personal possession of any employee?
That subject has never been addressed to me.
So as far as you knew from the custom and practice in the laboratory, it would be perfectly all right for a detective to take evidence, bring it home, and then deliver it to you the next day.
Sustained.
When Detective Lang gave you the sneakers, did you suspect that there might have been anything wrong in the way that he was delivering them to you for purposes of booking?
No.
Did you mention to Detective Lang that you had some questions about how he came to be in possession of those sneakers that morning?
No.
Did you mention it to Mr. Matheson?
Overruled.
I didn't mention it to him, no.
Do you believe, Mr. Fung, in accordance with the custom and practice of your laboratory, that detectives have 24 hours to book blood?
Overruled.
I have read that in the manual.
In the manual?
You showed it to me this morning, didn't you? Something like that? No?
What manual?
The LAPD manual.
You think in the LAPD manual there's a provision that says detectives have 24 hours to book blood?
I may be mistaken. There was something to that effect of booking as soon as possible or 24 hours or something like that.
Well, is booking as soon as possible the same as 24 hours as far as you're concerned?
Sustained.
Did Detective Lang ever tell you that detectives have 24 hours to book blood?
Overruled.
No.
Detective Van Adder?
No.
If you received blood on the morning of June 14th at SID for the first time, in your judgment, would that have been improper?
Sustained.
As far as you understood the guidelines of the Los Angeles Police Department, would it have been improper for either Detective Lang or Van Adder to have gotten the blood from Mr. Simpson on June 13th, kept it in their possession, and then delivered it to you in the morning on June 14th?
Sustained.
Your Honor, I'm trying to...
I understand what you're trying to do, but the foundation is not there.
All right. Let me ask you a hypothetical question. Let us assume that you received the blood that had been drawn from Mr. Simpson on June 13th on the morning of June 14th. You with me?
Yes.
If that had occurred, in your judgment, would that have been improper on the part of the detectives?
Sustained. Certainly. Problem here's foundation, counsel.
In terms of the custom and practice of your laboratory and its workings with detectives, would it have been improper if either of these detectives had kept the blood drawn from Mr. Simpson on June 13th overnight in their personal possession and then delivered it to you the next morning on June 14th.
Overruled.
That would depend on how the blood was stored in their, while it was in their custody.
You mean if they put it in their refrigerator at home, then in terms of your understanding and custom of practice, that would have been okay?
Overruled.
According to how I understand it, yes. I wouldn't recommend it.
Well,
Putting
why
in their
wouldn't you
own-
recommend it?
Putting blood in your own refrigerator, just wouldn't recommend it.
Well, isn't one reason that you wouldn't recommend it, Mr. Fung, is that in terms of chain of custody, it would be highly improper for a detective to keep a blood vial overnight?
Sustained.
Mr. Fung, are you fearful of these detectives, Van Adder and Lang?
I'm not fearful of them, no.
Are you aware, Michelle Kessler is the head of the laboratory.
Yes, she is.
Are you aware that her husband works as a detective in robbery homicide with detectives Lang and Van Adder?
Overruled.
Yes, I am.
Are you fearful, sir, that in a dispute between yourself and either Detective Lang or Van Adder, that you could not count on the support of Michelle Kessler?
No.
Did you receive Mr. Simpson's blood vial on June 14th after you received the sneakers from Detective Lang?
I received the blood vial from Mr. Simpson, of Mr. Simpson, on June 13th at the Rockingham address.
So your testimony is you did not receive the sneakers first on the morning of June 14th and then the blood vial.
That's correct.
Do you remember being asked on direct examination which item you received first, the sneakers or the blood vial?
I don't specifically recall that question, no.
Do you remember making a slip on direct examination when you answered that question?
No, I don't.
Your Honor, I'd like to show a piece of video. It's,
I'd like to see it first.
yes,
Does it have audio?
yes it does.
All right, let's ask the jurors to step back in the jury room, please.
I think it'd be done, all right, I'm sorry.
All right, let the record reflect the jurors have withdrawn from the courtroom.
Your Honor, how many times does the court have to admonish counsel to show us these things ahead of time? You know, and the grandstanding nature of these ploys has been made very apparent. This is the third time in front of this jury he's sprung tape on us, you know, without telling us ahead of time. The court has repeatedly admonished counsel to show us ahead of time and let us know.
Your Honor,
And
this,
repeatedly he's violated it, and once again, in front of the jury.
Well, the problem we have, though, is this is impeachment material. Let me see the tape.
well, this tape is his testimony.
It's impeachment
I understand.
material.
Yes, no, I'll
Do you
show
want to
this.
argue about this with me
No,
now?
no. I'll show the tape.
Show me the tape.
Yes.
Use the paperwork.
If the blood had remained item number 18, I would have had to create 3 additional property report face sheets.
Okay, now, with the pair of sneakers on the previous document that we saw was labeled item 17, is that correct?
Yes,
Which did you receive, and the blood 18?
yes.
Which did you receive first, the blood or the pair of sneakers?
I received the blood vial first.
All right. And
That's it.
That's ridiculous. And I'm sorry, but the fact that this is impeachment.
Ms. Clark, are you handling this witness?
No, Your Honor, I'm just helping Mr. Goldberg. But I'm not addressing an issue with the witness. I'm addressing an issue with counsel's.
Well, then we'll take that up later.
behavior in court.
Counsel, we'll take that up later. Mr. Goldberg, any comment?
I don't feel this is proper impeachment because it's not inconsistent. And also, for tactical reasons, we don't want to object to it.
And that's given counsel's conduct, Your Honor, and that's what I'm talking about.
Ms. Clark, didn't I just say we'll address this later? That means end of argument. I don't want to hear anymore. I'm tired of this. All right, 4 o'clock. We'll take it up.
Well, is there going to be any more videotapes?
Yes.
Would we inquire?
Yes, I have some more videotape that just came, and if she wants to see it,
So let's
up
see it
to the
now.
court. Could the witness leave the room?
Yes.
One tape I'm going to show the witness, Your Honor, is a videotape of he and Miss Mazzola, what I believe depicts them leaving the Rockingham location on the afternoon of June 13th. There's an audio portion to this that I'd like to have played as well. What I hear on that tape is Mr. Fung saying to the witness, "Let's go back for one last check." Then we have another tape.
Where'd you hear that?
Let me hear that again. And Ms. Fitzpatrick, can you crank it up?
represent to you that this is another version of the tape, but we're fast-forwarding to another section. When Mr. Shapiro was cross-examining Detective Van Adder, I was back in my hotel room, and I happened to see this tape. Okay. We propose to play the portion of the tape that...
Detective Fung would automatically take it to find protect for...
Not the
How do
audio.
you know that?
This is another shot, Mr. Fung and Miss Mazzola leaving on the afternoon of June 13th. Okay. We propose to show them those 2 seconds.
Mr. Goldberg?
I don't know the relevance this council would have to make an offer of proof. But furthermore, there's no showing here as to why this wasn't provided in discovery. We have another discovery violation. Mr. Scheck made some kind of a strange comment about having viewed it or seen it in his hotel room at some point. I don't know how that gets around the discovery obligations of the defense.
It's impeachment. I wasn't going to ask these questions. I wasn't going to show them this tape, Your Honor, until I heard what Mr. Fung had to say about how he carried this blood vial out there until he was nailed down. Now I'm going to show him the tapes.
All right, refresh my recollection. What specifically did he say? He said it was handed to him in a gray envelope and that he didn't recollect specifically how it was he carried it out.
He's had 3 possible ways that he could have carried it out. In a paper bag, in his posse box, or in his hand.
Okay. I saw him carrying a catalog case and a handful of paper bags.
Your Honor, before I'd like to make the rest of this offer of proof ex parte to you. I don't want to tell them. I think I'm entitled to that.
Well, counsel, you've just shown us, you've shown me a piece of videotape. You have to tell me why it's relevant.
Well, why it's relevant is that I believe that if I show these pieces of videotape to Mr. Fung and take him through, refreshing his recollection, looking at that, and take him through the events, that in combination with the testimony of Ms. Mazzola that the court has previously heard that's on the record, I think we can establish that what he's told us about carrying out that blood vial and how he carried it is not true.
And how do we do that from those 2 pieces of videotape?
Your Honor, I would again request that you permit me to tell you ex parte, make a record of it, and I will connect this up for you and show the plain relevance of it. I do not want to disclose that in front of these prosecutors who are going to talk to this witness or subsequent witnesses.
The witness, well, obviously, once you do it now, the cat will be out of the bag, so to speak. Mr. Fung is outside of the courtroom, and he's not
No,
hearing this information.
there's more to it. There are other witnesses, and there are other events, and there's other reasons why these tapes are clearly impeaching, and I don't want to say it in front of them. I think I'm entitled to make this offer to you ex parte.
What's your authority for that?
Well, I think it's impeachment material. And I don't think I should be required under the discovery rules to reveal the impeachment material before I'm impeaching the witness. There are...
No, but I have to make a ruling as to relevance and whether or not it's going to come in. Whether or not it's collateral, whether or not there's a 352 problem. What's your authority that you're entitled to an ex parte show?
my I'm informed that the exact rule in this jurisdiction is 1054.7, and if I'm permitted to make a showing under 1054.7, I think I'll be able to connect it up with the court and indicate to you...
No, that doesn't go to offers of proof regarding impeachment. That's a discovery rule.
You have me at in a dilemma here. Your Honor, what I'd like to do with the witness is show him these two segments that depict him and Miss Mazzola leaving Rockingham in the afternoon, and ask him which came first and which came second, to lay a foundation for further impeachment. And if the court wants to know beyond that what that impeachment is, I would request the opportunity to tell you very briefly what it is at sidebar. This involves testimony of another witness. We haven't impeached yet.
All right. Mr. Goldberg?
Your Honor, we've made an objection that it's not logically relevant. That's number one. We are entitled to be heard on that objection. Counsel is entitled to make an offer of proof if he so chooses, or not if he so chooses. But we are entitled to be heard on his offer of proof and fully litigate the issue of this tape's admissibility. The people do have a right to a fair trial, too, and we also have the right to be heard. We have the right to be heard on this issue, and there are only a very limited number of exceptions in our state for in-camera hearings. There are in-camera hearings for Marsden motions, for certain discovery issues under 1054.7. For something that's work product, there would be an in-camera hearing, but this doesn't fall under any of the known exceptions. The second objection that we have is we have an objection on the issue of discovery, and I know we've gone over and over this, Your Honor, and we've talked about that famous Izazaga footnote. I think it was 5, probably the court remembers, that it talks about the obligation to turn over or not to turn over impeachment material. And it is my understanding that if the defense had gone out and talked to Mr. Fung and gotten an inconsistent statement from him, they don't have to turn that over to us. If they intended to call their investigator as a witness, they would probably have to put that investigator on the witness list. But this is not the type of impeachment material that is described in that footnote to Izazaga. We are entitled to it. It is a tape, it is a piece of real evidence, and we are entitled to have it.
Mr. Scheck? Well, let me ask one further question. Mr. Goldberg, let's assume that you're entitled to have it. All right, let's assume I agree that you're entitled to have it since a videotape would be considered real evidence.
The only representation that we have from counsel as to how this videotape came into being or into their possession is that he was watching television, I guess, or looking at the videos in his hotel room and saw it. I mean, we have nothing in the way
No,
of any kind
let's
of-
assume for the sake of this argument, I agree with you that it's real evidence, that a videotape is quote-unquote real evidence, not a witness statement per se. In this context, where it is similar to a picture because it depicts actions by Mr. Fung and Ms. Mazzola at Rockingham, apparently on June 13th. Apparently. Could have been the 28th. I don't know.
And is the court's question, assuming that there is a discovery violation?
Let's assume there's a-
What is the remedy, or?
No, what are you asking for?
Well, that it not be used at this point. I mean, that we have the tape provided to us, that we have an opportunity to determine for sure what date this occurred on, whether there are any other sequences on the tape that would indicate when in a chronological sequence the events depicted thereon appeared. That is why we have a discovery statute.
What is
I'm
your
not
spe-
saying that the tape would necessarily be precluded, because we know that preclusion is usually a remedy of last resort for the court, and is something that we can rarely legitimately ask for.
What
But
is
there
your
are-
what is your objection to Mr. Scheck showing Mr. Fung these two videotape items and asking which occurred first, walking out with your catalog case or walking out empty-handed?
What is the relevance? That is our first objection. And the second objection was a objection on the discovery statute. And just to briefly restate, we were saying that we are entitled to be heard as to that first objection, relevance.
All right.
In terms of the relevance, I really want to determine from the witness which happened first. In examining the tapes, I've tried to reconstruct it based on what I see and based what my understandings of the evidence are, but I won't know till the witness tells me. And I want to review this with him to try to do the best I can to reconstruct the events of that day and to probe whether or not he really received the blood vial on the afternoon of June 13th. That's where I'm going with this. I think I should be entitled to show those tapes to the witness, inquire of him which happened first, which happened second, and then conduct further inquiry as to whether or not these tapes are, and further explore the credibility of his answers.
All right, what about our discovery problem, that the prosecution hasn't seen this, and I agree that it's probably real evidence?
Well, Your Honor, it's my understanding that I would be allowed to withhold this as impeachment material. That's my understanding. And these sequences are on the earlier tapes, but from different angles. And in fact,
When did you get these items?
well, I actually got this item about a week ago.
Which item?
The second tape that showed Mr. Fung walking out empty-handed and Ms. Mazzola with the trash bag. And I had recalled seeing something on the television, and when we reviewed this tape, we didn't review it to the very end, and we didn't see it, frankly, until last night, that the full segment was there. We've made efforts to obtain another tape that we think has even more of this footage, and I've not yet viewed that tape, but I understand that we're making efforts to find it. So we're trying to get all the footage we can of what happened, and I'm trying to show the witness the best I could.
And when did you get those items?
Which items?
This last tape,
Well, this
which was
last
actually
tape,
the first tape.
the first tape, I think, has been, I think the prosecution has that. The one of them initially coming out, I think has been seen before.
What we assume is initially coming out with the catalog case, correct?
Well, I don't know till I ask him which happened first and which happened second. I have a suspicion
All right.
based on his testimony.
Mr. Goldberg, do you have that first segment?
Your Honor, I've seen segments like this, but I don't think I've seen this segment. And the problem that I have with counsel's representation, and I'm not trying to say this as any kind of an insult or pejoratively, is that when they represented to us that we had the videotape depicting what they claimed to be the envelope Apparently, we do not have that, the envelope that was supposedly passed to Mr. Fung. And Mr. Fairtlow did a very extensive review of our tapes last night and says he does not find them. And I provided him with the counter on that item, and we just don't have it. So I don't think that we can, I can be comfortable that we have this simply because counsel has represented that we do.
As far as the last thing that Mr. Goldberg said, I'm informed by Mr. Blasier, who was the one that was dealing with this at the beginning of the trial, that the segments concerning the envelope and the glove that this witness was confronted with are on that KCBS tape, as we informed them yesterday. That I think is in evidence. So that, I think
Well,
that's...
that's another issue.
That's another, well, he braced it. Your Honor, looking at the tape, we did receive this particular tape which depicts Van Adder testifying and Mr. Fung and Ms. Mazzola walking out on April 5th. But we only saw the first segment. And last night, when we ran it to the very end, I saw the full segment, which I did recall seeing when Mr. Van Adder was testifying, but we couldn't locate it
All right.
in its entirety.
We'll do this. I'm going to allow the prosecution overnight, since we're going to break with the jury today at 4 o'clock. I'm going to allow them overnight to review these tape segments to see if they feel that there's any prejudice to them in the disclosure. At this point, Mr. Scheck, I would imagine you have enough to go on and fill the afternoon.
Well, actually, to be frank, Your Honor, this was...
This is it?
This is, the issue of the turnover of this blood vial is the last line of cross-examination that I have. I must say, Your Honor, until I know exactly what the witness says with respect to these tapes, and which segment is first and which segment is second, I won't be able to proceed to the very end, because it's dependent on his answers.
All right. Mr. Goldberg, does that sound acceptable to you? You have some opportunity to review the tapes, compare them with what you have, and we'll proceed tomorrow morning with continuing with Mr. Fung.
That sounds like it would be acceptable, Your Honor. May I just have a moment?
It's not like I don't have other things to do this afternoon.
Okay, Your Honor, there are a couple other legal issues that I did want an opportunity to address. One was as to the tape that I just mentioned, and the other was as to the phenolphthalein issue, which I think needs to be revisited in light of the cross-examination. I don't know whether the court would like to do that now or at some later point.
All right. My inclination would be to recess as far as the jury is concerned right now, come back in 15 minutes and discuss these other legal issues, and then commence our other hearing at 4 o'clock. And I anticipate being in session till about 6 on that. So we still have a full day ahead of us.
May I make one quick request that may save some time?
Sure.
May I ask permission to bring the witness back before we break and simply inquire of him without showing him any tapes, just through verbal description, if he recalls the events and which happened first?
All right, that seems reasonable, without the display of the videotape. All right. I'm sorry, you need a minute right now? All right, do you need to change paper? Okay. Court reporter needs 5 minutes. Don't go away. All right, let me give the court reporter a break. All right, let's take 5 minutes for the, well, we're so close. Let's just take our 15 at this point. All right, 15.
I ask an instruction that they not discuss this last matter with Mr. Fung.
I was hoping to finish Mr. Fung this afternoon. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Do not allow anybody to communicate with you. Do not conduct any deliberations till the matter has been submitted to you. And I know you have some activities for the evening, so I'm sure you're not too unhappy to get started earlier today. All right, we'll stand in recess as far as the jury is concerned until 9 o'clock tomorrow morning. And we will, as soon as the jury has been excused, we'll take up some of the other legal issues we need to discuss. And then we'll start our 4 o'clock session at 4 o'clock. All right, thank you, ladies and gentlemen. Back on the record in the Simpson matter. Mr. Goldberg, you wanted to raise an issue regarding phenolphthalein testing?
Yes, Your Honor. I thought the court had ruled that phenolphthalein was not going to be admissible, and then it became my understanding perhaps the court had ruled that positive tests were not admissible, but negative tests were.
That's correct.
The defense has now clearly introduced a positive phenolphthalein test without any prior approaching of Your Honor and trying to get a modification or clarification of the court's ruling, and it seems to be clearly in violation of what the court's ruling was. Aside from that, we also have the issue of the court having said that in terms of your phenolphthalein ruling, that you would not allow the defense in any way to place before the jury information or evidence that would be misleading in terms of negative results in certain locations, creating the inference that there was no blood in those locations. The defense put in evidence that there was a negative reaction in the sink drain or sink trap. And we know that, of course, we have a positive phenolphthalein test in the drain part of it. This clearly, without any doubt, creates an entirely erroneous picture, because it's almost as if you're telling the jury that this little spot over here was tested for phenolphthalein and it came back negative, when we know that the little spot next to it came back positive, and then arguing to the jury that there was no blood there. And what the defense has done is they have tried to create a change in what Evidence Code Section 352 is really intended to do.
Well, isn't your argument that the court's ruling was that no positive results of phenolphthalein testing would be admitted unless there was some backup or subsequent testing to confirm that, since phenolphthalein is a presumptive test only? However, that the state of the science is that a negative phenolphthalein was pretty much conclusive in and of itself that blood was not existent. So that was the state of the court's ruling. Then, during the course of the cross-examination of Mr. Fung this morning, I noted that the defense then offered through Mr. Fung positive phenolphthalein testing that had not been confirmed by any other testing method. So, having made the initial objection and then sought to themselves to introduce it, then your argument is probably that the prosecution's entitled to do likewise, correct?
Yes.
All right. Mr. Blasier?
Yes, Your Honor. Our purpose in asking that question of Mr. Fung, it's our position that that never happened, that test never happened. His testimony was that he had been sent back specifically to do testing on July 6th, I believe it was, and that he claimed that he went back and did that, but didn't tell anybody about it, didn't record it anywhere, didn't write a report until October sometime, where he then includes what he maintains was the test results. We did not ask that for purposes of establishing that there was a positive pheno test. We used it for impeachment purposes to show that that never happened. And it was not our intent to open up all other pheno testing positive results for admission as positive evidence of blood.
Well, isn't that, first of all, it's inconsistent with your previous position that I did grant your motion to restrict that use, the use of positive phenolphthalein testing without any backup, and then to broach that without asking for any limiting understanding with regards to that, or couching it in some other way, presumptive test, without mentioning phenolphthalein or anything else. Haven't you created a conflict, and is it now fair for the prosecution to bring this evidence in?
Well, I might point out there was no objection at the time that question was asked.
Well, I know there was no objection. I mean, they were probably hoping, I mean, I saw wide eyes over on this side of the table is what I saw.
Well, again, this was for purposes of impeachment of Mr. Fung. We don't believe that that test was ever done. It was evidence that he was purporting to have created for purposes of demonstrating that he did something on the 6th, which we don't think he did. And it's
But
our...
couldn't it have been couched in terms of an unnamed test, presumptive test for the presence of blood or some other way? I mean, couldn't it, and shouldn't you have given notice to the prosecution you were about to do that by asking to approach?
Well, may I have a mention? We had talked about, at a bench conference, about asking the question pertaining to the test of the sink trap, and I believe you were aware of that and had okayed that particular question. We chose not to do that with this impeachment material of Mr. Fung. We are very hesitant to reveal our impeachment material before we use it on the witness. That's the whole purpose of impeachment material. And perhaps we should have done that. We didn't do that. It certainly was not our...
That wasn't really true impeachment material in the sense that it was unknown and that there was some surprise advantage since you already had the transcripts in his testimony previously.
Well, I don't think there had been any testimony before about the fact that he did not write a report until October 6th, I believe it was. Mm-hmm. And it's our position that that delay of many months was a cover-up, to cover up the fact that, to cover his testimony in October because he had not done anything in July and that nothing was done, no testing was done. It's been our position all along with respect to Mr. Fung that this never happened. And I think it was appropriate impeachment material along those lines. If they want to ask him questions about it on redirect, I'm certain they'd be allowed to do that. But I don't think that that opens the door to all other pheno testing in other situations with other pieces of evidence.
Why not?
Well, because I don't think it does, because it was for a limited purpose of
But
impeachment.
see, you didn't ask me to limit the purpose. That was just general evidence that was just brought before the jury.
Well,
You didn't give the court notice. You didn't notify the other side because I had ruled in your favor, and then you go in and bring in something you asked me to keep out. So now it's out there for general purpose. There's been no advice to the court that I should give a limiting instruction to the jury. So isn't the door wide open at this point?
we have no objection to a limiting instruction. I think one was given before on this very issue. I may be wrong about that, but that's my recollection. But we have no objection to your advising the jury exactly what the nature of the test is, and that it's a presumptive test, and that this was a question that was asked for purposes of impeachment only.
All right, Mr. Goldberg, any other comment?
Your Honor, I don't want to take up more time with this than the court feels is necessary, particularly if you're inclined to rule in our favor.
Don't assume that.
Okay, well, maybe I will take up some more time.
No, I mean, let me ask you this. Do you have any case law? Because the case law, say, for example, in other presumptive tests, indicate pretty much what the court's ruling has been, that unless there's a 352 issue, and there are a lot of courts that have kept it out on that basis. Do you know of any other reported case that deals with a situation similar to ours?
Where they opened the door by introducing presumptive testing
Yes.
of one test? No, I haven't, Your Honor, but we do know of the rule of curative admissibility that are commonly referred to as opening the door, where where one side puts in evidence, the other side is entitled to rebut it. And let me point out the fallacy of counsel's argument is that there was no reason whatsoever that they had to ask what the results of the phenolphthalein test. There was no reason, as the court points out, that they had to ask what the nature of the test was specifically. Their alleged reason for doing it was simply to show that he had claimed to have done a test, but the result has no impeachment value whatsoever if they're trying to characterize it as impeachment or attacking the credibility of the witness. So the argument that they're making simply falls on that score. But I'd like to make two other arguments that I feel are also very important. Number one, the court, I think, was ruling under 352 of the evidence code at the time that Your Honor made its initial ruling. And what the court said is you said that you would not allow evidence to be put before this jury in such a way so that it were misleading. What we have is a situation where the defense has very extensively asked questions as to how much blood was in the Rockingham location, as to where it was, and very specifically asked whether the sink trap was tested and what the result was, and that it came back negative. Now, what earthly reason is there for asking that question other than to be able to argue to this jury that there was no blood in the sink and that he did not wash up in the sink? There is no other purpose for doing that. So how can you possibly allow a situation under 352 where they've been permitted to introduce evidence that there was a negative phenolphthalein in the sink trap when we know that there was a positive test in the sink drain itself? That is misleading. I think that what the defense is doing is they are trying to have the court convert 352 from a shield that's designed to protect you from overly prejudicial evidence into a sword that's designed to create an inference that there was no blood in these locations, when in fact we have a scientific test that says that there is. Your Honor, I would say on the score that if the court thinks that we need further foundation in terms of a serologist, we could conceivably have Mr. Fung simply testify to what he did in the color change and his observations and have someone else testify to the interpretation, although I don't think that step is actually necessary. So there is more than one reason for allowing this in. Opening the door is one, but fairness is another, and a proper usage of 352 is another. And this case should not be submitted to the jury in the posture that there is no blood and no evidence of blood when we know in fact that there is. And there is a reliable test that is used in the scientific community that suggests that. Also, I'd point out to the court that we did find out from technical experts that bleach does not cause a false positive with the phenolphthalein test when you use the two-stage method, which I speculated was the case, but now has been confirmed to be the case by experts that we have spoken with. May I just one moment? As to the first argument, it's also too late for a limiting instruction at this point. It came in for all purposes. The jury's not going to be back until tomorrow. And finally, I'd like to point out one other thing. In rehabilitating this issue, or readdressing this issue with Mr. Fung, we need to show what his practice is with respect to what he does when he gets a positive phenolphthalein test, or when he does a phenolphthalein test in general, because we can show that he does not write reports contemporaneously, an analyzed evidence report contemporaneously with that testing. He didn't do it when he tested the Bentley, so we need to get that in. He didn't do it when he tested certain other items at Rockingham, including the sink and the shower. He did not write an analyzed evidence report. So we need to show what this man's practice is and that it has been consistent throughout this case, and that is of vital concern to the people in addressing the supposedly limited issue that counsel says that the phenolphthalein test was introduced on.
That's exactly the point why it was important that he be asked the question about the pheno test being positive as opposed to being negative. We were not asking that question for purposes of eliciting the truth of the fact of what the pheno test was, but the fact that he said it was positive makes it a much more important event, one which he would record, tell his boss, tell Ms. Clark, tell somebody, than if it had been a negative test. So that particular piece of information was not offered for the truth of the matter stated. Far from it. It was offered for just the opposite, to show that by his testimony, that would be the important type of event that he would record. I'm not aware of any case authority on opening up the door with this kind of a question that opens up a whole scientific area as far as testing in other realms. And if the court is concerned about that, if the prosecution has any cases they want to cite, we'd like a chance to respond to those.
All right. Thank you, counsel. All right, I'm going to do a little more research on my own with regards to this particular issue, because I think the landscape of the issue has changed considerably since this morning. I felt very comfortable with the initial court ruling, but now that we have a different situation, I'm not so comfortable with it anymore. So I'll take a look at it over the evening hours.
Would the court want any testimony on this issue as to the phenolphthalein test?
No, I don't need that. The issue is whether or not the court having ruled one way at the request of one party, and then that party having decided to bring in that very thing, whether or not in fairness you're entitled to do the same thing. That's the issue. And within the rubric of 352. So I'll take a look. All right, any other legal conundrums you want to present to me?
There was another issue as to the videotape, Your Honor. Apparently, we did not get the exact copy of the videotape that was shown to the jury, the one with the counter in it, and the one that we have, according to Mr. Fairtlow, and I can't represent this on my own, is not shot from the same camera. May I just have one moment? They are the same, except that one has a counter on it and the other doesn't. So apparently one is edited and the other is not. And we would like the exact same version, because there may be a difference in quality or clarity, which would resolve the issue that was raised as to exactly what item was being handed.
All right, Mr. Blasier, do you have any problem searching your videotape file, making available to the prosecution the same exact footage with the counter in it rather than the counter removed?
They already have it, Your Honor. Mr. Fairtlow could not find the clip with the envelope and the glove on the blanket. He said he went over the tape in great length. I showed it where it was on the tape, and I think he's satisfied that at least those clips are on there. The clip for the counter are on there someplace as well. We've given him that tape. I think it's also on the first tape that we introduced, which is Court's Exhibit Number 2. I think that's the same tape. But we've given them that tape at least twice, and it's on there.
All right, you're saying that's on Court's Exhibit 2?
I think that's the KCBS tape that we had introduced very early on. Whether that has the one with the counter on it, I'm not sure. There are a lot of clips. There's probably 7 hours of tapes that we've given them. That's a compilation of 7 tapes, which we'd also given them. And there are a lot of repeats, a lot of repeat clips, and we made those excerpts from that 2-volume set. So, and we didn't do any editing ourselves, other than to take the clips out.
All right. Well, it seems to me if it's the same footage, then there's no additional need. I know that Ms. Hazlett is still searching for the original format of that particular tape so we can see if it's available for enhancement purposes. And if we locate that from the news media, I'll let both parties know as soon as we do. All right, I see it as a non-issue at this point. All right, anything else before we launch into our 4 o'clock matters?
Yeah, I think one thing you said, we reset the date for the motion that we had filed that was set this afternoon, and at your convenience, you can just tell us what's a good date for that. There was another 4 o'clock meeting that you'll
Yes,
have
I know.
at your discretion do.
Yes, well, I'll tell you what, let's see where our 4 o'clock hearing today takes us
I see.
time-wise, because it's extraneous to the presentation of evidence to the jury, and I want to see what kind of time obligations I'm going to have to spend with that issue before I commit to a hearing on the other issue.
That's fine.
All right.
Which motion is counsel referring to?
Referring
The
to,
prosecutorial misconduct motion that was set at 4 o'clock today. And
Which
I-
prosecutorial misconduct motion?
Choose either one.
I think it's in volume 2. Okay, anything else before we await the parties for the 4 o'clock matter? All right, for the news media information, I normally conduct my jury inquiries in chambers. I will make a transcript of the proceedings available to you as soon as the transcript's available for today's proceedings, probably first thing tomorrow morning.
Now you're on the jury proceeding, Your Honor.
Yes, sir.
Regarding Mr. Simpson, Mr. Simpson has expressed a desire, Your Honor, to be present, and I know the court's ruling with regard to chambers, but he would like to be present for any hearings regarding the jurors from this point forward, and I'd ask the court to consider that. Perhaps we can do it in the courtroom with him out here, perhaps.
As far as non-jurors are concerned, I'll grant that request. As far as jurors are concerned, I'll decline that request. Those inquiries will be conducted in chambers with counsel present on the record, without the presence of the defendant.
All right, thank you.
Non-juror witnesses will be interviewed in his presence,
Very well.
or including non-jurors includes ex-jurors. You're welcome. Okay. All right, we'll await the arrival for the parties for the 4 o'clock matter. All right, thank you, counsel.
Thank you.